Hi, and welcome to the Wake Podcast. I'm one of your hosts, Alejandra Moreno.
And I'm Taylor Kaufman.
And today we're going to be talking about what happens if you pass away with or without a will, but the beneficiaries of your estate are a minor. So let's talk about it.
Okay, so we spoke about capacity in a previous podcast. And in the eyes of the law, someone under 18 doesn't have the capacity to receive an inheritance.
That's
for
right.
Probate or even a settlement, right? If they receive a settlement from some case, they don't have the capacity to receive it. So a lot of times when a minor, someone under 18 receives an inheritance, a guardianship has to be open and that money is held in a guardianship until that minor turns 18.
That's right. And we have seen cases where people have passed away, young people, unfortunately, and they were not married. There is no will, but there are minor beneficiaries. And that's where we have the baby mama or baby daddy drama.
Yes.
Because technically under the statute, the person entitled to serve as personal representative is your next of kin. But in this case, your next of kin is a minor. They can't do it. So under the statute, after that is going to be your parents. But now you have maybe your parents representing the estate for the benefit of their grandkid, right? But they're not the natural parent.
Right.
And then you have the natural parent saying, but like, why do you get to do all this probate stuff when the money goes to my kid? So it gets a little fuzzy, right?
Yeah, baby mama drama or baby daddy drama gets a little hairy. And in that case, if the minor is, entitled to receive a settlement, we have the natural parent stepping in.
Yeah, and so in the probate case, we have the drama of who's going to be personal representative. Is it the parent of the person that passed away? Or is the parent going to waive their right and say, I don't want to do this, and then have they're not technically really, their grandkid's parent serve as personal representative, but that person technically doesn't have the right under the statute, and the beneficiary has to consent, but the beneficiary is under 18, and the parent's going to sign the consent, but of course they're going to consent to themselves, so they kind of have a conflict.
Yes.
There's, it's not pretty. So usually we do have the parent of the deceased person as the personal representative, but once that probate case is closing up, now we need to open a guardianship, and that money's going to go to the natural parent, the remaining parent, and that money is going to sit in a guardianship until they turn 18, and then they're going to get it in one shot, right?
It's going to go to their child.
Yeah.
And sometimes, a client doesn't really have a choice if it's going to the parent or if it's going to the minor. Sometimes their parents, are deceased, they predeceased them, and, that money in the estate is going to the minor. So the, baby mama or baby daddy is going to be the personal representative in the probate case.
So, and that's why we always say, like, when is the right time to at least have a will? Definitely before you need it.
Yes.
But if you have a kid, you should have some estate planning document. And we'll talk about, what are the, not red flags, but I guess when do you know that it's time to do your estate plan? But if you have a kid, nobody thinks that this is going to happen to young people, but we see it all the time. It's sad. Yeah. It's terrible. But having at least a will, something in writing, at least like that part of the drama is, canceled out.
Right. You're not going to have your ex-wife or husband or baby mama or someone, representing your estate. At least you can avoid that.
Yes. So once the probate case is wrapped up, the beneficiary is a minor. We have to open up a guardianship case.
Right.
And the funds from the estate, the probate restricted account is transferred now to a guardianship restricted account. And we say, the money's going to sit there until they turn 18. Yes, because it does. And it really depends on the judge, right? Because depending on how much money, depending on the judge, depending on the circumstances, there are judges that allow us to use some of that money for, college accounts.
Right.
So we start putting a little bit of money away. So when that child turns 18, they're not just getting a bunch of cash, but they do have their college paid for.
Yeah. And like you said, it really depends on the judge. There's a wide array of judges, and we've seen some judges that are very pro-investment, and they allow this money to be invested for the minor's future and, a college prepaid plan or some sort of investment account. So it's not just sitting there. But we do have other judges that are like, they mandate that this money be put into a guardianship restricted account and just sit there. They want to make sure that the money is safe and untouched and preserved for when the child turns 18.
And that order that we get from the court that blocks an account, it has certain language, and some banks will not accept it, right? Some banks will not serve as a restricted depository or a court blocked account.
Yes.
Or some will serve as a court blocked account, but because the court order has that depository language, they can't accept it. And there are some judges in, you know, some counties that they're like, well, as long as it's court blocked, it's okay.
Yes.
Let's let it grow. Let's let it invest. And some judges are like, no, the statutes say it has to be a depository. If that bank is not a depository, find another bank.
Yes.
And, you know, some banks might allow us to have an investment account so that money can grow. But some banks say if it's not $1 million, we can't do it.
Yeah.
You know, if it's not 500,000 or 100,000, we can't do it.
Yes.
And, you know, having, especially, you know, the way the economy is, having these funds in basically like a checking account, it's, you know, a financial advisor would say it's losing money.
Yeah.
Right. But it really depends on the judge. And, you know, I don't want to sound like I'm criticizing. These judges have a huge responsibility, right? These judges have thousands of cases, and some of them are this way because they are in a way responsible.
Yes.
You know, when this child turns 18, they might look at the judge and be like, why did you allow this money to go out? Why did you allow this money to be put in this account?
Yeah.
Or like, you know, a risky investment or whatever. So I think some of the judges are more fiscally conservative because it's a big responsibility.
Yeah, it is a big responsibility. And on the same topic, another issue that we see a lot is, you know, a child receives some sort of inheritance or a settlement and it goes into a guardianship restricted account, and then the parent wants to access those funds, you know, to either, you know, put a down payment on a house that the, you know, the minor would live in, or for braces or for after school activities or something. And, you know, a lot of times clients come to us with these, you know, requests and it, you know, like we said, it really depends on the judge, but it also depends on like what the money's gonna be used for. And we've seen some judges allow a certain amount of money, you know, usually pretty small, of money to be taken out to be used for the minor's benefit.
Right.
And other times we've seen the judges completely shut it down and say, you know, it's the parent's responsibility and we're not going to let any of this money out. It's going to be preserved for the minor.
And there are many cases where I agree. As a parent, you have certain responsibilities. You have certain financial responsibilities. In some cases, you know, depending, of course, on all of the facts of the case, who the parents are, you know, the amount in the restricted account, sometimes having access to that money before they turn 18 could change the course of their life.
Of course, yeah.
It really could be a huge benefit to somebody who might not, you know, have that ability, right, in their family life. It's a tough call.
It is. And we're not criticizing here saying it would help some and not others, but we're really just making an observation, and we want our clients to be informed of like what goes into a guardianship and what the court's going to allow and what they're not going to allow. And
we've seen cases where, you know, parents are like, my son or my daughter has this money just sitting there. Can I use it for a down payment on a house? And a judge, that's where it gets tricky, because let's say the judge says, yes, let's use it. The judge is not going to put a minor on the title of the property, right? We've talked about that in previous, you know, episodes. That's a huge liability. But what if that child turns 18 and the parent is like, no, that was my down payment. I let you live here, but now it's my money.
Right.
You know, is a judge going to get into a parent borrowing from the guardianship? What interest rate? What? No, go to a bank and borrow it.
Yeah.
So it's so tricky and it's so delicate that I see why judges, they're pretty firm on what they allow, what they don't allow. Because at the end of the day, when that kid turns 18, the judge knows like that money has to be there.
Right. The money's going to be there for the kid. And it's hard too, right? It's a hard conversation to have with our clients, you know, just to kind of shed light on it and have them understand where these judges are coming from. Because in their eyes, it's like, you know, it's my kid's money, but it's going to help my kid, you know? So it's a hard conversation to have, but we like to be upfront with our clients and tell them it can go one way or the other based on the judge. And, you know, sometimes even if we know the judge and we tell the client something, if they insist, at the end of the day, we work for these clients, you know, so we will go ahead and, you know, ask the judge, and, you know, every case is different. The facts of the case are different. So,
and we practice in so many counties. We've gotten to know these judges, what they're okay with, what they're not okay with. And like you said, that's a hard conversation to have when a client is like, I want you to ask the judge. And we're like, look, I've been doing this for a while. I know this judge, they're going to say no. I don't care. Do it anyway. I'm going to charge you my hourly rate to do this, knowing that it's going to be a no. You're okay with that. Okay, well, then we got to do it.
Right.
But we're not charging usually the client the hourly rate. We're charging from the guardianship funds. Yeah. So sometimes I'd rather charge less and know that we're doing the best thing for the ward, even if the guardian is not thinking about the best thing for the ward. But we represent the guardian. So like you said, they're the boss.
Yeah.
If they say do it, at least try. We got to try.
No, it's hard. It's hard. The guardianship is definitely a different process than, probate and everything else. But it's, the money is held and it's really at the discretion of the judge. But it is avoidable.
And we have relationships with certain bankers at certain institutions that know how to work with court orders. They know how to work with guardianship accounts. We know that, the client is in good hands. And a lot of these, financial planners, they help the kid once they turn 18 to not blow all the money on a Ferrari. And we've had a few, kind of take these kids under their wing and teach them things that I think should be taught in high school, but it's not. Financial literacy, getting on a budget, how to continue to invest, take a little bit of this money, use it now for whatever fun stuff you want, but don't blow it all. So it goes a little bit beyond the guardianship case. It goes into kind of helping families that might not have the knowledge, or helping minors that might not have guidance. We have guardianships of minors that a grandparent is the guardian because the only parent passed away. So it's an emotional game too, to try to help these people do what's right. It's not just like, okay, let's petition the court. We're trying to, we get a little bit invested.
Yeah,
right.
No, we do.
We get a little bit invested. But I think that's what helps us do what's right for the client. And then, the kid turns 18, and I've had a lot of clients come back and, their kid's 25 now or 30 and they're doing so well. And thank you for introducing us to this financial advisor who has helped, put them on the right path. And that is just as rewarding.
Yeah, that's a nice story. Yeah.
Yeah. So thank you for joining us, talking about when a guardianship might be avoidable, right? Because with a proper estate planning, you don't have to deal with any of this. You can make sure that your beneficiary is taken care of and those funds are not going to sit in a guardianship. So tune in next time where we'll be talking about when a guardianship is not avoidable. Thank you for joining us from ASM Law Group, preserving what matters most for those who matter most. The Wake is for informational purposes only and does not constitute legal advice. The discussions in this podcast are meant to bring awareness to important issues, but they should not be considered a substitute for professional legal guidance. If you need legal advice tailored to your specific situation, please consult a qualified attorney.